Dear students, subscribers, and the viewers, welcome to the IAS Mentor. So, in our series Indian Polity, we are moving to the next lecture. So far we have completed 44 lecture in this particular series, and we are almost going to complete the directive principles of state policy also. So, in this lecture, I would complete the directive principles of state policy. So, once I complete this, then I'll take up the fundamental duties in one lecture, and then we'll touch upon certain areas like the basic structure doctrine, the amendment to the constitution, and of course some practice questions. So that would be the part 1. Probably I would divide the entire Indian polity into 3 parts. So part 1 basically deals with all those things. That means by this, once I complete whatever I said, we'll be covering 1/3 of the subject, and the other things will be covered in the coming lectures. So with that introduction, we'll directly get into lecture number 45, where we are going to discuss about the liberal intellectual principles. So far under the directive principles of state policy, we have already covered the socialistic principles and of course the Gandhian principles also. And in the previous lecture, I have just started one liberal intellectual principle, that is the Uniform Civil Code. So that is also covered. So apart from the Uniform Civil Code, we'll touch upon the other liberal intellectual principles, and then we'll also learn certain other things of the directive principles of state policy. So article 44, in the previous lecture, I have elaborately discussed about the Uniform Civil Code. In fact, we try to understand what is Uniform Civil Code, and do we have an Uniform Civil Code right now in India? What are the challenges to this Uniform Civil Code? What are the people who are usually in favor of Uniform Civil Code? What is their argument? What is the argument of the people who are against the concept of Uniform Civil Code? What kind of debates has happened in the Constituent Assembly of India? And what is the opinion that is given by the Supreme Court in certain cases like the Shah Banu case or the Sarla Mudgal case? And what is the opinion that is given by the 21st Law Commission? So that's a comprehensive discussion with regard to Uniform Civil Code. So if you want more information, you can go to my previous lecture, that is lecture number 44, where I have discussed about the Uniform Civil Code. So now we'll move forward with the other articles. See article 45, early childhood care and education up to 6 years. So in fact, this is in line with the number of policies that the state is taking. Say for example, early childhood care up to 6 years, the immunization programs or the ICDS program, or various other schemes related to taking care of the child. So these are all in line with what is called as this article 45 of the Constitution. Article 48, organize agriculture and animal husbandry on modern scientific lines. Today the effort that has been taken by the government with regard to animal husbandry, with regard to the green revolution, in fact we have gone for multiple green revolutions in our country, the introduction of high yielding varieties, the establishment of institutions like ICAR and other agriculture research institutions. These are all in line with what is called as to organize agriculture and animal husbandry on modern scientific lines. Article 48, to protect and improve environment and to safeguard the wildlife. So the state has enacted what is called as a Wildlife Protection Act. The state has enacted what is called as the Environmental Protection Act. And apart from that, today we have a lot of areas like the national parks, biosphere reserves. So all these things are in line with ensuring Article 48 of the Constitution, which is 48A of the Constitution, which is giving one directive as the state should take measures to protect the wildlife and the natural environment. Article 49, to protect monuments, places and objects of artistic or historic importance. So for example, today we have a specific body which is called as Archaeological Survey of India. So this ASI is one body which takes care of various historical buildings or probably various other historical places, excavation of various places. So this is all in line with what is called as Article 49. In fact, today the government is spending a lot of things in protecting various historical monuments. So this is all in line with what is called as Article 49 of the Constitution. Article 50, separation of judiciary from executive. So when you talk of separation of judiciary from executive, this is in line with the principle of separation of powers in the Constitution. So in order to make sure that there is separation of powers, today what is the role of executives and what is the role of judiciary is been clearly demarcated under the procedural laws. And one such example is a criminal procedure code. If you see the criminal procedure code, it clearly demarcates as to what is the power of the judiciary and what is the power of the executives. Say for example, what is the power of the police and what is the power of the judges. So who has to prosecute and who has to conduct the trial. So the clear function has been demarcated. The police has no authority to punish. It is only the judiciary which has got the authority to punish. The police can probably only prosecute, who are part of the executives. So that's basically what is called as the separation of judiciary from the executive. So these principles are laid down in number of laws in our country, including the criminal procedure code. To promote international peace and security. So in line with this particular directive, India has got number of initiatives which does promote what is called as international peace and security. Say for example, India's nuclear policy of no first use is in line with promoting international peace and security. So our stated policy is, will not use nuclear weapon in the first instance, and will not use a nuclear weapon against a non-nuclear state. But we have what is called as a credible massive deterrence. That means we'll go for a massive second strike. That's a different thing. But we will not initiate a nuclear strike. That's our stated policy. We have our stated policy of what is called as neighborhood first policy. That means we'll give priority to our neighbors. We will give a lot of things to our neighbors, even if it is going to be to some extent lost to India. Right from the commencement of the Constitution, India has been following the principle of what is called as non-aligned movement. Whether that is relevant today or not, that's a different thing. But at that point of time, it was very relevant. So our policy of non-alignment. Even today, the Panchshil policy is followed in our foreign relations. Say, for example, non-interference in the internal affairs of another country, peaceful negotiation of issues. India does involve in peaceful negotiations with China, be it a border dispute or be it some dispute with Bangladesh or be it some dispute with Nepal. So in all these cases, we go for what is called as peaceful negotiations. So this is all in line with what is called as promoting international peace and security. So with that, we are coming to end of the directive principles of state policy. Usually from where the questions are asked, first of all, you should know that the directive principles of state policy is non-justiciable in character. That means it does not restrict the powers of the legislature or the executive in doing something. Second thing is, you should understand that they are classified into three types: Gandhian, liberal intellectual and socialistic principle. But however, this distinction is not there in the Constitution. It's only for our own understanding. This distinction is made as per the ideologies. So you should be in a position to identify which is Gandhian, which is liberal intellectual, and which is what is called as socialistic principles. That's one area where UPSC is asking question. The third important area is also the constitutional amendments that has happened to this particular part. What are the areas where the constitutional amendments has happened? So that is what we are going to understand right now. So we'll move to that particular area. Come. So there are few amendments that has happened to the directive principles of state policy, which was not there in the original Constitution. But today, subsequent to the enactment of the Constitution, certain provisions has been inserted. So what are those provisions? We'll try to understand. In fact, a number of provision was inserted by the 42nd Constitutional Amendment Act. So what are the amendments by the 42nd Constitutional Amendment Act? To secure opportunities for healthy development of the children. Article 39F was inserted by the 42nd Constitutional Amendment Act. So try to remember. In fact, UPSC does ask a question from this particular area. We spoke about what is called as free legal aid, which is a socialistic principle in Article 39A. That was brought in by the 42nd Constitutional Amendment Act. Secure participation of workers and management in industries. Article 43A, again a socialistic principle inserted by the 42nd Constitutional Amendment Act. To protect and improve environment, that is Article 48A, which is a liberal principle. So try to know it falls under what type of principle also. Again, 42nd Constitutional Amendment Act. So only in 42nd Constitutional Amendment Act, 4 amendments or 4 DPSP was inserted. So all the other constitutional amendment just brought in one change. 44th Constitutional Amendment Act, state to minimize inequality in income. So they have made some changes in Article 38 as to how to ensure the social order. One of the way is by minimizing the inequality in income. 86th Constitutional Amendment Act, it allowed for what is called as early childhood care and education for all children up to 6 years. In fact, 86th Constitutional Amendment Act has not only made changes in Article 45, not only made changes in Part 4 of the Constitution, that is Directive Principles of State Policy. In fact, the 86th Constitutional Amendment Act has made changes in the other two parts in the Constitution. What are the other two parts apart from Part 4? So please put the answer in the comment box. So let me see how many students are participating in such questions that I put in the various class. So 86th Constitutional Amendment Act has made changes in 3 parts in the Constitution. Along with Part 4, what are the other parts? And then 97th Constitutional Amendment Act 2011. So that made change to Article 43B, which brought in the state to promote formation, control and management of what is called as cooperatives. So basically 4 amendments you have to remember: 42nd, 44th, 86th and 97th. So also remember which article or which provision was inserted by which amendment. So most likely if you remember 42nd, the other things becomes little easier. The other things are not difficult. So try to remember 42, and 86 is related to education. So you can remember this. 86 is also related to education in fundamental right. So already given one clue. So which part the 86th Constitutional Amendment Act has amended apart from Part 4 of the Constitution. 97th is related to what is called as cooperatives. So this also made changes in the fundamental rights also. Alright, so this is one area where they can ask you question. So now, before we complete this particular topic, let us quickly get into some of the criticism of this directive principles of state policy. Of course, there are some utility, there is no doubt, because the directives are a great source of direction to the state as to what they are supposed to do and what they are not supposed to do. And that is why it is also said that the directive principles of state policy are similar to that of what is called as instrument of instruction. But however, there are some criticism to this directive principles of state policy. What are they? So first and foremost, critics say that the DPSP is illogically arranged. What do you mean by illogically arranged? They're not arranged in a proper sequence. See, you go to the Part 4 of the Constitution, you will understand that some socialistic principles are there in between Gandhian principles, in between liberal intellectual principles. So it is not that they are segregated in the Constitution, but it is for our understanding, it is segregated in some of the books, but not in the Constitution. That is why the critics say that it is illogically arranged. No legal force, and we already seen the reason as to why there is no legal force. We already had an enough discussion as to why it was not made legally enforceable. In fact, Dr. B.R. Ambedkar said, although it is not legally enforceable, in a parliamentary democracy or in an electoral democracy, no government can afford to let it loose, because the electorate will answer at the time of elections if the government is not implementing that. So that is the answer. And then this directive principles of state policy has led to a lot of constitutional conflict. In fact, the constitutional conflict is with the fundamental rights. So there are a lot of cases that I wanted to discuss, probably as I'll move through to the last part of the discussion in today's lecture. So other criticism is it has led to a lot of constitutional conflict. In fact, the judiciary has to, in number of cases, determine what if there's a conflict between fundamental rights and DPSP, which will prevail. So this is something that the judiciary has interpreted and given a judgment. So it has also led to a lot of constitutional conflict. So these are all some of the criticism of DPSP, but at the same time, nobody can ignore the utility of what is called as the directive principles of state policy. One foremost utility is that it is similar to that of instrument of instruction. So instrument of instruction was there in the Government of India Act 1935, giving some instructions to the state as to what or how they are supposed to carry out their functions and responsibilities to ensure the welfare state. So similarly, it is acting like an instrument of instruction. It helps judiciary in interpretation of the constitution. That is of course true, which will understand that how they have been used in some of the significant cases like Minerva Mills case, subsequently when I proceed. And they also ensure what is called as social and economic justice. Say for example, most of the principles in the directives are related to what is called as equality. Most of the principles are socialistic in nature, so they all ensure social and economic justice. There is no doubt, be it prevention of concentration of wealth in the society, redistribution of wealth in the society, free legal aid to the poor, or free assistance by the state in old age, free education, right to work. They all try to ensure what is called as social and economic justice, and hence it's very, very important part of the constitution. And of course, they also ensure accountability of the government. How do they ensure accountability of the government? As I already said, that the state has to implement all those things. We've already seen that though they are moral obligations, that means there's no legal obligation for the state to implement any of these things. They are majorly moral obligations, but still, if the state is not implementing these things, then at the time of elections, people might not vote to that particular government. And therefore, that government can be voted out of power. And therefore, it brings in an element of accountability on the part of the government to implement all these directives. And some of the people who felt that the DPSP has a lot of utility, and one such utility also, the DPSP act as a common political manifesto. So what do you understand by common political manifesto? By common political manifesto means be it the ruling party and opposition party, whoever comes to power, they have to implement these directives. These are all some minimum directives which are aimed at ensuring the welfare of the people. So therefore, it also ensures certain element of continuity. Say for example, irrespective of the government that is there in India, the government has continued the PDS, public distribution system. Irrespective of the government that is there in India, the government continued various social assistance schemes. Irrespective of the government, the party which has formed the government, they continued providing public health care. They continued providing what is called as free education, because these are all the things which is part of what is called as the DPSP. And hence it acts as a common minimum program for any government that would occupy the power in our electoral democracy. Okay, but our entire understanding of the directive principles of state policy will not be complete unless and until we understand the conflict between fundamental rights and the directive principles of state policy, where it all started in what is called as the Shankari Prasad case. Or even before Shankari Prasad case, I would say the Champakam Dorairajan case. Now, Champakam Dorairajan case I discussed when I was discussing Article 15 of the Constitution, and subsequently a lot of other cases are also there. But why Champakam Dorairajan case is very significant? Because try to understand, it was in the Champakam Dorairajan case, the reservation that was given to the backward classes and the scheduled caste and scheduled tribe was declared to be invalid. And it was found to be violative of Article 15 of the Constitution, because Article 15 says no discrimination on the grounds of religion, race, caste, sex, or place of birth. So what happened in 1951? The state of Madras was trying to give some reservation in the educational institutions, especially in the professional educational institutions. And what they said, why they wanted to do it, that the reservation was in line with Article 46 in the Constitution. If you read Article 46 of the Constitution, which is part of the DPSP. So if you read Article 46 of the Constitution, which is part of DPSP, which says that the state shall take measures for the advancement of the weaker sections, the state shall take measures for the advance of the backward sections. So the state of Madras is of the opinion, by providing reservation to the backward community, so we are trying to make them advanced. We are trying to help them to come forward in life. But however, this affirmative policy of the state of Madras to implement the provisions of Article 46 was challenged, that it is violative of Article 15. So that's basically the Champakam Dorairajan case has to decide. So the Champakam Dorairajan has to decide, what if there's a conflict between fundamental rights and DPSP? So the state of Madras is saying that we are giving reservation to the backward community to implement Article 46. But people who are against reservation, they argued that it is in violation of Article 15. And it was argued that Article 15 is part of fundamental rights, whereas Article 46 is part of DPSP. Fundamental rights are justiciable in nature. DPSP is not justiciable in nature. So in case of this conflict, which is likely to prevail or which is to be given the primacy, the Supreme Court has given primacy to the fundamental rights, of course, because that is part of the justiciable one and that is enforceable in a court of law. So therefore, in case of conflict, the primacy was given to the fundamental rights. In fact, later we will understand, to nullify this particular judgment only, the constitution was amended and they brought in Article 15 class 4. I already discussed all those things. If you want to again have a visit, go back and look into my discussion on Article 15. I do not remember the lecture number, but you can go and look into discussion on Article 15. So the primacy was given to the fundamental rights. The situation continued in the Golaknath case. In the Golaknath case also, the fundamental rights were given an immutable position. That means the Golaknath case asserted that the fundamental rights has a transcendental position in the constitution. That means no fundamental rights can be taken away. So the position of fundamental rights was even strengthened both in in Champakam Dayarajan case and further later in what is called as the Golaknath case. Although there are a lot of things that you have to discuss regarding the Golaknath case, I'm not doing it right now. I'll discuss that when I take up the doctrine of basic structure. I'll have a broader discussion on all those things. So in both the cases, the fundamental rights were given primacy. So the state was not able to carry out a lot of welfare measures because whenever there's a conflict between fundamental rights and DPSP, the primacy was given to the fundamental rights. So to avoid that, two important amendments has happened by the Parliament. One is the 24th Constitutional Amendment Act, and then they also brought in what is called as this 25th Constitutional Amendment Act. I'm sure that you will remember what is this 25th Constitutional Amendment Act. It is a 25th Constitutional Amendment Act that inserted what is called as Article 31C. Article 31C was inserted, and through Article 31C, it was said that whenever a law is made to implement either the provision of Article 39B or the provision of Article 39C. So in this case, Article 39B or Article 39C, a law is made to give effect to them. And in the process, even if Article 14 and Article 19 is violated, still which would provide? Still the directive principles of state policy or the law made to give effect to the directive principles of state policy would prevail. And to that extent, for the first time, the primacy was given to what is called as DPSP through this amendment explicitly. And then the 24th Constitutional Amendment Act, just before the 25th Constitutional Amendment Act, they also made sure the constitutional amendment can take away the fundamental rights. So till this point of time, an immutable position was given to the fundamental rights. But by the 24th Constitutional Amendment Act 1971, it is clearly said that the constitutional amendment can take away any of the fundamental rights. So no constitutional amendment can be challenged in a court of law on the ground that it is violative of the fundamental rights. The only ground on which a constitutional amendment can be challenged is on the grounds of violation of basic structure. That also did not evolve here. That subsequently came in the Keshavananda Bharati case. But by 24th Constitutional Amendment Act, you'll have to understand that what has been explicitly put in the Constitution, that a constitutional amendment can take away the fundamental rights. So therefore, the immutable position that was given to the fundamental rights in the previous cases was taken away. So that is a development that has happened here. Then came the Keshavananda Bharati case. So the Keshavananda Bharati case almost upheld the validity of these amendments. That is the 24th Constitutional Amendment Act as well as the 25th Constitutional Amendment Act. They said that the fundamental rights are not immutable. It is not that the fundamental rights cannot be amended. The Parliament under Article 368, they can amend any provisions of the Constitution, including the fundamental rights. The only restriction on which the amendment cannot happen, or the only restriction to the power of the Parliament to amend the Constitution, is what is called as the basic structure. So that basic structure was innovated. So Here you can see the primacy which was earlier given to the fundamental rights has been now reduced to what is called as basic structure, which means you try to understand after the Keshavananda Bharati case in 1973, can the parliament amend the fundamental rights and can take away any of the fundamental rights? Yes, they can take away the fundamental rights, no doubt. But what the parliament cannot take away is that anything that would constitute part of the basic structure. Even if some of the fundamental rights are part of the basic structure, they can also not be taken away. So the only way any constitutional amendment can be challenged is on the grounds that they shall not be violative of what is called as the basic structure. So that is the basic understanding you should have. Then came the most important case, which was trying to balance between the fundamental rights and DPSP. What is the next case? That is Minerva Mills case. For Minerva Mills case, you should have an understanding of this 25th Constitutional Amendment Act. Now, what is this 25th Constitutional Amendment Act is saying? So, 25th Constitutional Amendment Act inserted Article 31C. And by that Article 31C, it is saying that if any law is made, either to implement Article 39B or Article 39C in directive principles of state policy, that law, even if it is in violation of Article 14 and Article 19 in fundamental rights, cannot be declared to be invalid. So that means Article 31C was giving primacy to Article 39B and Article 39C over Article 14 and 19 in fundamental rights. So that means between fundamental rights and directive principles of state policy, the DPSP is given a higher position, but only with regard to Article 39B and Article 39C, not with regard to other DPSP, but only against Article 14 and Article 19. Now, this primacy which was given to Article 39B and Article 39C was extended to the entire DPSP. So, by the 42nd Constitutional Amendment Act. So, the 42nd Constitutional Amendment Act in 1976 said that not only to Article 39B and Article 39C, but the entire DPSP. So, if any law is made to implement any of the DPSP, right from Article 36 to Article 51. So, if any law is made to implement any of the directive principles of state policy, they cannot be challenged on the grounds of violation of Article 14 and Article 19. So, this is the change that was made in by the 42nd Constitutional Amendment Act. That means, to put it in a very simple way, the primacy that was given only to Article 39B and C over Article 14 and 19 was extended to the entire DPSP over Article 14 and 19 by the 42nd Constitutional Amendment Act. Now, this was challenged in the next case, which is called as the Minerva Mills case in 1980. In the Minerva Mills case, the Supreme Court said that this extension which was given to the entire DPSP over Article 14 and 19 is unconstitutional and invalid because it is disturbing the harmonious balance between the fundamental rights and DPSP. On the one hand, fundamental rights is justiciable in nature. On the other hand, DPSP is non-justiciable. Though DPSP is non-justiciable, you cannot ignore the importance of DPSP because DPSP would ensure the collective welfare of the society. It would ensure the welfare of the people in the community. And therefore, somewhere or the other, it has to be balanced, although it is non-justiciable in character, that is the DPSP. And to that extent, to maintain this balance, we allowed the laws made to implement Article 39B and Article 39C over Article 14 and Article 19. But to say the entire directive principles of state policy would have primacy over Article 14 and Article 19 would not be acceptable. So, therefore, to that extent, we are declaring this 42nd Constitutional Amendment 1976 as unconstitutional. Not the entire amendment, to this extent, where it was trying to give primacy to the entire DPSP over Article 14 and Article 19. And therefore, the Supreme Court also declared that the harmonious balance between fundamental rights and DPSP is part of basic structure. And any amendment in the future which would disturb this harmonious balance can also be declared to be invalid because it is violative of the basic structure of the Constitution. So, the position what was held by the Minerva Mills case even continues today. So, even if you see today that Article 14 and Article 19 goes out when Article 39B and Article 39C comes in. So this is basically, by this judgment, the Supreme Court is trying to maintain the harmonious balance between fundamental rights and the directive principles of state policy. Alright, so with that we are coming to the end of the directive principles of state policy. So what are the areas usually questions come? You should have a basic idea as to what does it mean by non-justiciable. Second thing is, what are the classification of the fundamental rights? So they can ask you, give you DPSP principles and ask you to identify what type of principle is this. Sometimes they can give you directive principles of state policy along with fundamental rights and duties and ask you to identify the directive principles of state policy. Fourth area is that you should be aware of the various amendments that has happened to the directive principles of state policy. So sometimes they can give you some initiatives. Say for example, Mahatma Gandhi National Rural Employment Guarantee Act, Old Age Pension Scheme, and probably they can give you Environmental Protection Act, or probably they can give you what is called as Disabilities Act. So if they give all these four options, and they can ask you which of the above laws or initiatives are related to the directives given in the part 4 of the Constitution. So you should be able to correlate these directives or these laws or initiatives to some of the directives in the DPSP. In fact, most of the laws in our country or the policies of the state, one way or the other, they are directly or indirectly related to the directive principles of state policy. So if you have any doubt in such questions, usually the answer would be all of the above. But however, it may vary from question to question. So see whether there is fundamental right or something. So in this way, you'll have to apply your mind, but otherwise, mostly the answer would be all of the above. So with that, we are coming to the conclusion of lecture number 45. But before that, we'll have a quick question and then we'll wind up this particular session. Come to the question. Which of the following was inserted into the DPSP by the 86th Constitutional Amendment Act? So what was inserted by the 86th Constitutional Amendment Act? Free legal aid to the poor, protect and to improve the environment, state to promote formation, control and management of cooperatives, early childhood care and education to children up to 6 years of age. So if you know the answer, you can put it in the comment box. So with that, we are done with this particular lecture as well. So far, what are the things we have covered? We have covered the basics of polity. We have covered the salient features of polity. We have seen the historical underpinnings. We have seen the Constituent Assembly. We have seen the preamble to the Constitution. We have seen the part 1 of the Constitution, that is Union and its territories. We have seen part 2 of the Constitution, that is citizenship. We have seen part 3 of the Constitution, that is fundamental rights. And of course, we have seen part 4 of the Constitution, that is directive principles of state policy. In the next lecture, I'll touch upon the fundamental duties. And after that, I'll take upon the doctrine of basic structure and amendment to the Constitution. And of course, some practice question. By lecture number 50, I would be able to cover up all these things. So please do watch all these lectures and try to watch them in a chronological order for the maximum benefit. If you have any friends or family members preparing for UPSC or other competitive examination, you can also refer them this particular series and it will be immensely beneficial to all of them. And as I already said, it is also very important that you prepare for the interview also right from the beginning. It doesn't mean that you'll have to unduly divert your attention towards interview, but having a basic understanding of what UPSC interview and what is expected, what kind of qualities and what kind of personality you'll have to groom. So these are all very important from the very initial stages for you to get the maximum marks. There are always exceptions. We are not concerned about the exceptions. We are concerned about a common person, probably a person in the first generation who has never appeared for the examination. Someone like me. I am someone who is a first generation who prepared for the UPSC examination from my family. And in the process, I had a lot of learning, lot of failures. So that's the reason I wanted to share all these experience with a lot of aspirants who are the first generation people who are preparing, and the first generation is always going to be very difficult and very tough. So that is the reason that probably these guidance could help you in doing well. So for that, I have done a separate series on how to prepare the interview test. So probably you can watch those lectures as well, which will give you a lot of insights. It's a very short series with 4 videos where I've segregated as to how you can start your preparation and how you can plan your preparation for the interview. All right. So with that, I'll wind up the lecture. And if you have any queries, related to this particular lecture or any of the other lectures, you can reach out to me through my Instagram account or through my Telegram channel. With that, I'll wind up this particular lecture. Thank you very much. Keep watching. All the best.